Hello, everyone. Welcome to our first lecture on the general principles in transportation law. Contract of transportation is when a person obligates himself to transport persons or property from one place to another for a consideration. The contract may involve carriage of passengers or carriage of goods. The person who obligates himself to transport the goods or passengers may be a common carrier or a private carrier. Contract of carriage is one whereby a certain person or association of persons obligate themselves to transport persons, things, or news from one place to another for a fixed price. The parties in a contract of carriage of passengers are the common carrier and the passenger. A passenger is still considered such even if he is being carried gratuitously or under a reduced fare, subject to Article 1758 of the Civil Code, which states that when a passenger is carried gratuitously, a stipulation limiting the common carrier's liability for negligence is valid. Also, in one case, the Supreme Court held that a complaint for breach of contract should be dismissed against the employee who was driving the bus because the parties to the contract of carriage are only the passenger and the bus owner or operator. For the carriage of goods, the parties are the shipper and the carrier. The shipper is the person who delivers the goods to the carrier for transportation. The consignee is the person to whom the goods are to be delivered. The consignee may be the shipper himself or a third party who becomes a party to the contract either by the relationship of agency between the consignee and the shipper or consignor, the unequivocal acceptance of the bill of lading delivered to the consignee with full knowledge of its contents, or when the third person demands before the carrier the fulfillment of the stipulation made by the shipper in the consignee's favor. If the carrier subcontracts the transportation of goods, the carrier remains liable to the shipper or consignee. There is no privity of contracts between the shipper or consignee and the subcontractor. However, the carrier has the right to be reimbursed by the subcontractor for whatever damages that it may be made to pay to the consignee due to the fault of the subcontractor. The subcontractor is the carrier of the carrier. Hence, in the claim for reimbursement, the presumption of negligence that applies to common carriers also applies to the subcontractor. The elements of a contract of carriage are consent, object, and consideration. Consent is given by the carrier on one hand and the passenger or the shipper as the case may be. Written contract is not essential. Object is the prestation, which is the transportation of the passenger or goods from one place to another. And consideration, for the carrier, is the fare or freight to be paid by the passenger or shipper, while consideration for the passenger or the shipper is the promise to transport the passenger or the goods. The Supreme Court has adopted, in one case, the view that there are two types of contracts of carriage of passengers. The first type is the contract to carry, that is, an agreement to carry the passenger at some future date. This contract is consensual and is therefore perfected by mere consent. The second is the contract of carriage itself, that should be considered a real contract, for not until the facilities of the carrier are actually used can the carrier be said to have already assumed the obligation of the carrier. With respect to carriage of goods, there may be a consensual contract to carry goods, where the carrier agrees to accept and transport goods at some future date. However, by the act of delivery of the goods, that is, when the goods are unconditionally placed in the possession and control of the carrier, and upon their receipt by the carrier for transportation, the contract of carriage is perfected. With respect to buses, jeepneys, or streetcars, the Supreme Court explained in one case that once a public utility bus or jeepney stops, it is in effect making a continuing offer to bus riders. Under this continuing offer rule, it is the duty of the drivers to stop their conveyances for a reasonable length of time in order to afford passengers an opportunity to board and enter, and they are liable for injuries suffered by boarding passengers resulting from the sudden starting up of the carrier. Liability of the carrier is already based on contract. It follows that the passenger is deemed to be accepting the offer if he is already attempting to board the conveyances, and the contract of carriage is perfected from that point. So that's it for our first lecture in this lecture series on transportation law. Thank you for listening.